Hi, I'm Jessica Eves Matthews. Welcome back. And this episode is Trademark 101. What the heck should I trademark? Today, we're going to be tackling one of the most common questions I hear from founders, and that is, what should I trademark and what is trademarkable? If you've ever wondered whether your business name, your logo, or your tagline needs trademark protection, or if you're confused about what even qualifies for trademark protection, then stick around because by the end of this video, you're going to know exactly what you can trademark and how to pick a brand name that's actually protectable. So here's what we're going to cover today. I'm going to walk you through the four things that every founder needs to know about trademarks. Number one, what a trademark actually is and what you can protect. Number two, the trademark strength spectrum and why your name choice matters more than you think. Number three, the practical steps to search and secure your mark. And four, when to file for registration and what it costs. So let's dive in. So let's talk about number one. What is a trademark really? A trademark is any word, phrase, symbol, design, or combination of those things that identifies and distinguishes the source of your goods and services from someone else's. Think of it as your brand's fingerprint in the marketplace. And here's what you can trademark. You can trademark your business name. You can trademark logos, product logos, taglines, slogans, even distinctive packaging, even colors in some cases, like Mattel's pink is trademarked, Tiffany's blue is trademarked. You can even trademark when I say packaging, like Coca-Cola's glass bottle, the original bottle, that is trademarked. Air Jordans have some trademarks related to the design features on their shoes, as do other designers. You can even trademark a smell like Play-Doh or a sound like Intel, bum 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 is trademarked, or an action. So if a car has like a scissor door action like a Lamborghini, that is also trademarked. So there are a lot of things that you can trademark. Anything that would be considered as a source identifier. So if somebody sees it, they know it's your brand and not somebody else's. That can function as a trademark. So in more sort of normal cases, think of like the Nike swoosh. That's a logo. Their tagline is "Just Do It." And so those are the types of things that you should be looking for in your business to use and protect as a trademark. But here's a key insight that a lot of founders miss and frankly get wrong entirely. Not all brand names are created equal. And the strength of your trademark depends entirely on where it falls on what us trademark attorneys call the distinctiveness spectrum. So that's going to bring us to number two. What I mentioned before is the trademark strength spectrum. Picture a ladder with five rungs, and at the top, you've got the strongest, most protectable marks. At the bottom rung are marks that are essentially impossible to protect. So let's start at the top. Those are called fanciful marks. And these are made up words that didn't exist before the brand created them. So think of Xerox, Kodak, Google. These are the gold standard because they have no meaning outside the brand itself, which also means no one else has ever used that word before. The next rung down are what are considered arbitrary marks. And these are real words that are used in a completely unrelated context. So if that makes sense, they're used arbitrarily. So they're called arbitrary marks. So Apple for computers, Amazon for e-commerce, Camel for cigarettes, etc. The word exists, but it has nothing to do with the product. You're not going to get a sense at all from the word about what the product is, its qualities, benefits, features, nothing. Then the middle of the ladder is what are called suggestive marks. And these hint at a quality or characteristic without describing it. So Netflix is a really great example of that type of mark. It suggests that these are movies delivered via the internet. You can kind of tell from the name what they do. That's a made up word. Greyhound is another suggestive mark because it suggests speed, right? So you kind of get a sense of a quality or feature of what they offer, but it's not entirely clear from the mark. For it to be a suggestive mark, the consumer has to make a mental leap to understand the connection to the mark. But if they do make that mental leap, then they probably will understand what it means. So now we're getting weaker. The next rung down is descriptive marks. And these marks directly describe the product or service. Cold and creamy for ice cream, for example. Speedy delivery for a shipping company. These are fake names I'm making up, but these are just examples. These types of marks are really hard to register unless you can prove that they have acquired what's called secondary meaning through, and that really only comes through extensive use over time. It can also come if the mark has been wildly successful and has a really big following and has made a lot of money. But generally, you're looking at least 5 years of use of the mark before you can claim distinctiveness for most marks. So that takes a strategy that takes a long time to develop distinctiveness. And until you have, you cannot register those marks. And then the bottom rung is they're completely unprotectable marks and they are generic terms. So you can't trademark the word computer for computers or coffee shop for a coffee shop because that would give one company a monopoly on common words and phrases. And we aren't going to let that happen. Okay, so now let's jump to step 3, which is practical steps for searching and securing your mark. So what does this mean for you as a founder? Here's my practical advice. First, when you're naming a business or a product, you need to aim for those top 3 rungs. You do not want something that's descriptive. It's tempting, I know, to pick something that's descriptive because it does tell consumers exactly what you do. And you may feel that because of that, it's going to make it easier for them to find you if they're doing like a Google search or something. But actually, that same clarity makes it nearly impossible to protect your mark and easy for competitors to copy. So while it might be theoretically easy to find you on the internet, and maybe you think, oh, if I have a URL that describes what I do, then people will be able to find me. But what happens is you get lost in the crowd because lots of other competitors are going to be using similar words and phrases to describe competitive products and services. So the last thing you want to do is pick something that is descriptive because it doesn't help you stand out in the marketplace. You want your trademark to be memorable. And the only way it's going to be memorable is if it's unique. So keep that in mind. And if you're tempted to copy a mark that exists, don't do it. That's going to open up a whole other type of headache for you. And it's going to make it almost impossible to protect it through federal registration or otherwise. And so you really want to avoid that type of mark. Second, before you fall in love with a name, before you spend the money to buy the URL or start doing logo design or, God forbid, even putting it on your products and services and marketing with that mark, the first thing you need to do is go to the United States Patent and Trademark Office's website. That's the USPTO's website, and use their free search tool called TESS, TESS. And in that, you can look for identical or similar marks in your industry. It's not entirely easy to use. It's a little confusing. This is why I recommend using a good trademark lawyer to help you with these searches, but it's a good place to start on your own initially before you even think about bringing a lawyer in, because if you do find a mark that is identical or similar to yours, and when I say similar, I mean maybe it uses a Y instead of an I in the name, or maybe it's 2 words that are pushed together, or a word that is broken into 2 parts, but basically it's the same. So those types of similarities or different variations of the same type of word. If somebody's already using something similar to your name, walk away. Do not use that mark. Third, I want you to think beyond just your business name. So you need to think about trademarking signature product names, your logo, your taglines, like we talked about, because you are building brand equity around all of these things, not just your name. And in fact, logos and taglines often end up becoming the most recognizable part of companies' brand and brand identity. So make sure you don't ignore or neglect those things as you are developing what your business name and your other brands are going to be. Here's a pro tip for you. You don't need to wait until you file your federal registration to start using the TM symbol. I don't know if you guys have seen that. It's like a little subscript, because that little TM doesn't mean you have a registration. It's just putting the world on notice that you're claiming rights to that mark. That is going to put other people sort of on alert, and it gives them a quick opportunity to understand that that mark is already being used so somebody doesn't copy you, ideally. The circle with the R around it, though, that is only for federally registered marks. So do not use that until you have federal registration secured. Okay, so let's talk about the next step, which is when to file for registration and what it's going to cost. So timing matters enormously. And I don't know if you even know this, but you can actually file a trademark application even before you're using it. So whether you're using it already in commerce, meaning offering goods or services for sale across state lines, which if you have a website, generally you meet that. Most businesses are in commerce these days because people are moving from state to state through interstate commerce on the highways and traveling. And so if there's even a chance that you could be selling a good or service to someone who is traveling, for example, you're in interstate commerce. So if you're selling something, you probably are. And there are exceptions to that, obviously, that a trademark lawyer could help you understand, but I would assume you probably are. But if you're not using it yet, if you haven't actually started making sales, you're not actually offering your goods or services yet, you can still file a trademark application. And that is on what's called an intent to use basis. And that means that you are planning to launch soon, but you have not launched yet. Many founders wait too long to file for registration. And by the time they try to register, someone has actually beaten them to it. Or worse, they built an entire brand around a name that they can't actually protect. And here's a little pro tip for you. When you file an intent to use application, it gives you priority rights in that name from the date of the filing of that intent to use application, even if you're not using it yet. Now, in the US, priority is generally built off of when you begin using the mark. But when you're filing, if you file under an intent to use, you get the benefit of that earlier date if you end up in a dispute with another party who comes after you. So there's an additional incentive to file on an intent to use basis before you are even using the mark. Here's my recommendation. Start the trademark process as early as possible. Budget $300 to $400 for the filing fee. But I would recommend, I mean, you certainly can do the application yourself through the USPTO website. I do not recommend using services like LegalZoom or Rocket Lawyer, any of those. They are not giving you any legal advice. You are paying them whatever their current fee is for the benefit of them taking whatever you tell them to put in the form and putting it in the form. They're not going to review it. They're not going to tell you if it's accurate. They're not going to tell you what your chances are of getting approval. Using those services are not going to help you or improve your chances of registration. They're just taking your money. So if you're going to do it yourself, just do it directly through the USPTO website. However, I strongly recommend, even though it sounds very self-serving, that you hire a trademark attorney to help you do the research, because trademark lawyers have access to paid databases that lay people do not, and they can help you understand as early as possible what the risks are that you're facing by using that particular mark. And the sooner you figure that out, the better, particularly before you start spending money on the brand and packaging and inventory that's got the brand on it, et cetera. Okay, so if you're sitting there thinking, this is great, but I need help figuring out what it is to trademark for my specific business, I've got you. Set up a call with me. I do free consultations and we'll work through this together. We'll look at your brand, at your products or services. We'll look at your competitive landscape, and we will build a trademark strategy that actually makes sense for where you are and for where you're headed. And so you can just grab a spot on my calendar for a free consult and we can talk about that. So let's recap the 4 things that every founder needs to know about trademarks. 1, a trademark protects your brand identity, including names, logos, and taglines, among other things. 2, you need to aim for fanciful, arbitrary, or suggestive marks because they are the strongest and the most predictable and most protectable. And 3, search before you commit. And you can do it by using the USPTO's free test database. Better yet, hire a lawyer to help you do the search. And 4, file your trademark registration as early as possible, ideally as an intent to use, so that you aren't waiting until it's too late, and so that you can basically plant your flag in the ground and have priority rights over anybody that might come behind you and try to use the same name or a similar name. And in an upcoming video, we are going to tackle what happens when someone infringes on your registered trademark. You've done the work to protect your brand, and now someone else is using it or something confusingly similar. What do you do? How do you respond? We're going to walk through those steps in a future video. So thanks for listening, and I'll see you next time.